The parties in this case are Terrence Byrd and the United States government. In September of 2014, Byrd's at-the-time girlfriend and mother of his children had rented a vehicle from Avis, a rental car company. Byrd had been granted permission from Letitia Reed and given the car keys to drive the vehicle. Byrd had been driving on a highway when an officer pulled Byrd over for a traffic violation and asked for his license and the rental car agreement. In the rental car agreement, Byrd was not listed as an authorized driver. The officer then asked Byrd if he had any contraband within the vehicle. Byrd conceded that he did have a marijuana joint. The officer asked Byrd if he could search the vehicle. Byrd did not consent to the search, but the officer proceeded to tell Byrd that he could search the vehicle regardless of his consent because he was not authorized under the rental agreement. Upon searching the vehicle, the officer discovered blocks of heroin and body armor within the trunk of the vehicle. As a result of that search, Byrd was indicted for several crimes. The core issue in this case is whether a driver has a reasonable expectation of privacy in a rental vehicle when the driver is not listed under the rental agreement, but has permission from someone who is authorized under the rental agreement. So the Constitution does not explicitly mention privacy, but privacy is a concept that can be found in a number of rights that the Constitution gives rise to. The Fourth Amendment states that a person has a right to be free from unreasonable searches and seizures of their person, houses, papers, or effects. A vehicle would fall under the effects provision of the Fourth Amendment. There is a legal distinction between owning and renting property, but in the context of the Fourth Amendment and privacy, that line isn't so clear. The strongest argument that Byrd can make is that Fourth Amendment protections don't hinge on contractual rights and don't hinge on ownership. There are Supreme Court cases that establish that an overnight guest of a home has a reasonable expectation of privacy in the home. That's Minnesota v. Olson. It didn't matter whether or not the overnight guest owned the home. The court still decided that there was a reasonable expectation of privacy. In another case, Katz v. United States, the Supreme Court determined that an individual has a reasonable expectation of privacy in a phone booth. In that case, the individual didn't own the phone booth as well. The government is arguing that privacy is rooted in property rights. And here, because Byrd does not have a cognizable property interest within the rental vehicle, he does not have a privacy right protected by the Fourth Amendment. He's not authorized under the rental agreement. He can't exclude others from driving the vehicle. Even though he has permission from his girlfriend, she's a renter, she's not someone that owns the vehicle. And so, given that the property belongs to someone else, he can't claim a protected interest in driving the vehicle. If the Supreme Court decides that there is no reasonable expectation of privacy in the vehicle, then contracts may start to play a greater role in determining whether or not Fourth Amendment interests are protected.